Good morning, everyone, and a very warm welcome to the Myerson Solicitors Commercial Agency webinar, today, Tuesday, the 5th of April, 2020. My name is Suzanne Carr, and I'm a Senior Solicitor in the Dispute Resolution team at Myerson. If I could start today by taking you through some housekeeping points. This webinar is being recorded and will be circulated to those of you that have attended today, as well as posted on our YouTube channel. You will have noticed when you joined the meeting that your microphones were automatically placed on mute, and I'd ask if you can please keep them on mute for the duration of the webinar. Please ask any questions you have through the chat function, which you will find in the icon bar on your screens called chat. I will answer the questions at the end of the webinar, and if you could please keep your microphones on mute during the question and answer session, that would be appreciated. The presentation will last around 15 minutes. Moving on to the agenda for today. I will start by looking briefly at the relevant legislation, the Commercial Agents Council Directive Regulations 1993. We will then consider who is a commercial agent and is therefore afforded the protection of the regulations. Then moving on to some of the issues which agents may be encountering as a result of the current pandemic. We will look at the rights of agents who are not being paid. We will then move on to the rights of agents who are asked to renegotiate the terms of the agency. And finally, sales targets. What are the risks if those are not being met? I will then look at some of the practical steps you can take to preserve your termination rights and consider how the value of termination payments may be impacted by COVID-19. We will then end with the question and answer session. So let's start by looking at the legislation which applies to commercial agents in England. The Commercial Agents Council Directive Regulations are commonly referred to as the Commercial Agents Regulations. These regulations implement the European Directive relating to self-employed agents under English law. They will continue to apply to commercial agents since Brexit by virtue of the European Union Withdrawal Act 2018. The regulations continue to operate and be effective and will do so unless and until the law is amended to a future date by the UK Parliament. The purpose of today's webinar is not to explore in detail who is defined as a commercial agent, but it is worth reminding ourselves of the key requirements to satisfy that test. And also a reminder that a commercial agent can be either an individual or a company. So the agent must sell or promote goods, not services. The agent must be performing its sales activities in Great Britain. It must be self-employed and, critically, must be independent from the principal. It must have the authority to negotiate, but that is construed very widely and does not necessarily require an agent to have the authority to conclude sales. It will include, for example, agents whose role is simply to introduce third parties and to generate further business. An agent's authority must also be continuing. It is a misconception that agents must be paid by way solely of commissions. Typically, agents are remunerated on a commission basis, but not always, and commercial agents can be paid by way of a fixed retainer or a mixture of both. And finally, as we commonly see, there is no requirement for there to be a written agency agreement. One of the main issues I anticipate agents will be encountering in the midst of this pandemic is the non-payment of their remuneration, whether that be by commission or retainer. If principals are unable to manufacture their goods because of the current lockdown measures, this is bound to have an impact on their ability to comply with orders placed by customers, and the result may be an unwillingness or even an inability of the principal to pay its agents. So what protection is afforded to commercial agents in this scenario? Well, where an agent is remunerated by commission, it is afforded protection under Regulation 7. Agents are entitled to be paid commission on transactions which are concluded during the agency, and that can be either because the transaction is concluded because of their efforts, or because the transaction is with a customer or in an area which is exclusive to the agent. The agent's commission will become due as soon as the transaction is concluded, and that usually means when the product is delivered. Now, the regulations helpfully provide a long stop date for the payment of that commission. The latest date the commission becomes due is when the third party has executed its part of the transaction, or where the third party should have executed its part of the transaction. And the commission must be paid to the agent no later than the last day of the month following the quarter in which the commission became due. I appreciate that might sound slightly complicated, but the important point here is that the only time commission will not be payable to the agent is when the sale does not proceed, and that is not due to any fault of the principal. If the order does not proceed and the principal is not at fault, then the commission entitlement would be lost. However, if the principal is at fault, then the commission will remain payable. So let's consider two possible scenarios. If a customer simply cancels an order, for example, by an email or written notice, then the agent would lose his right to commission because the order cancellation is not due to the fault of the principal. If you contrast this with the position where the customer rings the principal, for example, or sends it an email and asks it to allow it to cancel the order, i.e. seeks its permission essentially, and the principal agrees. In that case, commission would remain payable to the agent even though the order is not concluded, because the principal has allowed the customer to cancel the order, and the principal's conduct has therefore contributed to that cancellation. Now, an agent may not be sure of the circumstances surrounding the cancellation of a particular order, and without more information will not be sure if the commission is due or not. It is therefore vital that the agent tries to find out how and when the order was cancelled. So knowledge of the agent is paramount. An agent should seek confirmation from the principal as to how and why the order has been cancelled, and ask for that confirmation to be put in writing. The agent should also ask for copies of correspondence exchanged between the customer and the principal, so it can determine how the order was cancelled. And the agent is entitled to demand this information under Regulation 12, and that is so that he can check the commission that is properly due to him. If the principal fails to pay the commission in breach of its obligations under Regulation 7, this will give the agent a right of action, and the agent will be entitled to bring a claim in the court for payment of the commission owed. It could also potentially entitle the agent to bring the contract to an end whilst preserving its rights to a termination payment. However, it is important the agent seeks advice before taking any steps to bring the agency to an end. We then move on to the frequently encountered scenario, which is that an agent is asked by his principal to renegotiate the terms of the agency or possibly to sign a new contract. This issue is likely to become even more prevalent in the current circumstances because of the downturn in sales. The current circumstances mean that principals may well feel they have no option but to seek to make such changes to support their own businesses in circumstances where they are unable to manufacture and market products for a significant period. Trade fairs, for example, which are a key part of marketing for most agents, will of course not be taking place at the moment or for the foreseeable future. Agents are often unsure as to whether they are required to agree to a request to vary the terms of their agency. It is important to say that each case will have its own set of facts and must be considered on its own merits. However, as a general rule, a principal cannot demand that an agent agrees to vary the terms of the agency where the proposed change is fundamental. So, for example, if an agent is asked to agree to a significant change in territory, or an agent is asked to change its remuneration structure or the rate of commission, or an agent is asked to permit the principal to take key accounts in-house, each of those changes is likely to be deemed to be a fundamental change, and an agent would be within its rights to refuse to agree. Principals must be careful not to seek to impose a fundamental change on an agent, as this could amount to what is called a repudiatory breach. And in the context of the regulations, a repudiatory breach is a breach of the contract which is so serious it entitles the agency to be brought to an end with immediate effect. A demand to sign a new contract on different terms may amount to a repudiatory breach by the principal, and this would entitle the agent to terminate the agency with immediate effect, but still preserve the termination rights. However, again, this would need to be considered carefully in the circumstances of each case before an agent takes such steps. A further consequence of the decline in sales might be the failure to meet sales targets. It is common for sales targets to be contained in a written agency agreement. So if there is a written contract, the starting point would be to consider the terms of that contract. Some agreements may contain a clause which states that a failure to meet sales targets will entitle a principal to terminate the agency without having to pay a termination payment. And whilst agents may understandably be concerned about the effect of such a clause, it is unlikely to be enforceable. It is highly unlikely an agent's failure to meet sales targets will entitle the principal to terminate the agency with immediate effect. And this is particularly the case where the failure is a result of COVID-19. That is because the agent's failure to meet its sales targets is due to circumstances which are beyond its control. Contrast this to the situation where an agent has failed to meet its targets simply because of its own poor performance. In that situation, it is possible that such a failure, particularly if that failure is ongoing, may entitle a principal to terminate the agency with immediate effect. But even in that scenario, it would still be difficult. So if an agent is faced with the threat of termination because of a failure to meet sales targets, the agent is advised to seek advice so that the appropriate steps can be taken to preserve termination rights. And don't panic, it is unlikely that such a failure can be deemed to be a repudiatory breach. So moving on to preserving termination rights. Most agents will be aware that the key protection afforded by the regulations is an entitlement to receive a termination payment upon termination of the agency. And that can be either by way of compensation or an indemnity, and both can be substantial. And there are steps an agent can take to protect those rights. Firstly, an agent should always comply with its obligations insofar as it is able to do so. It should continue to perform the agency to the best of its ability, and importantly, ensure that all reporting requirements are met. If it can demonstrate to the principal that it has taken all reasonable steps to promote the principal's goods and can evidence those efforts, then that will stand the agent in good stead should the principal terminate the agency. Agents should also ensure that they assert their rights, and that should be in writing if possible. I appreciate this can have its practical difficulties. We commonly hear agents say, "I was asked to sign a new contract, and although I was not happy with the changes, I felt I had no other option but to agree. I did raise objections, but then carried on as before." Agents are often reluctant to voice their objections and may feel a sense of inequality when it comes to a request to renegotiate terms. And whilst there is an understandable desire to want to keep the principal happy and on good terms, an agent's failure to assert his rights can lead to difficulties later down the line. Agents should therefore put their objections in writing. If an agent is asked to sign a new contract and objects to the changes, but only voices its objections verbally, it is going to be much more difficult to prove later down the line that the new terms were not agreed. And that can lead to difficulties if the principal subsequently asserts that the new terms were accepted. If circumstances arise in which an agent is unable to meet his targets, then the agent should inform the principal as soon as possible, so that the principal is aware of the situation and the reason for the failure. Finally, moving on to the impact of COVID-19 on the valuation of termination payments. It is likely we will see an increase in the number of agencies being terminated due to the current pandemic, and this may have a consequential impact on the value of an agent's termination payment. So let's look at that in a little more detail. I mentioned earlier that there are two forms of termination payment: indemnity and compensation. Compensation tends to be the more common alternative. Provided an agent has preserved his termination rights, he will be entitled to an indemnity or compensation if the agency is terminated by the principal. The value of both could be affected by the fall in sales due to COVID-19. So why is this? Both are calculated in very different ways. An indemnity is designed to reward the agent for the fact that he has significantly increased the principal's business. It compensates the agent for the fact that the principal will continue to derive an ongoing benefit from the business he has introduced. There is a cap on the level of an indemnity. It cannot exceed more than a year's average earnings, and that average is calculated based on the last 5 years' earnings, or less where the agency has lasted for a shorter period. If there is a decline in sales due to COVID-19, this will have a negative impact on the average earnings figure over that period, and therefore the cap on the amount of the indemnity will be less. Now, it remains to be seen how the courts will approach this, but it may be that if an agent can demonstrate that the decline in sales over a certain period is solely due to COVID-19, then that period may be excluded for the purposes of the average earnings figure and ultimately have no impact on the value of the indemnity cap. Compensation, on the other hand, is calculated as the notional price a hypothetical purchaser would be willing to pay for the agency at the date of termination. There are various methods for calculating compensation, but generally it requires the identification of the net maintainable earnings figure. In other words, what earnings were likely to be made in the future had the agency continued. Once that figure has been calculated, then an appropriate multiplier is applied. When experts are calculating compensation, they will look at the revenue earned by the agent in the period prior to termination as a guide or starting point. If the agent's revenue tends to fluctuate, then typically the expert may look at a longer period of revenue, say between 3 and 5 years, in order to determine the maintainable earnings figure. However, if the agency tends to provide a steady income, then it may be appropriate only to look at the last 12 months of commissions. And the actual revenue earned by the agent before termination is then used to project the future revenue. So it is easy to see that if there has been a significant decline in sales due to COVID-19 prior to termination, this could have a negative impact on the maintainable earnings figure. Experts may argue that the period where there has been a decline in sales due to COVID-19 is not indicative of a permanent trend and should not be taken into account. But no doubt principals will seek to try and take advantage of the decline in sales and use this to argue for a lower maintainable earnings figure and indeed a lower multiplier. It is unlikely, in my view, that the courts will be willing to depart from the current methodology for valuing compensation, where to do so would unfairly and adversely affect agents. After all, the regulations are designed to afford protection to agents, and the case law we have seen over the last decade or so has typically been very agent-friendly. Where a business suffers a significant but temporary decline in sales due to COVID-19, it would seem very harsh to penalise the agent in these circumstances. However, if the decline in sales is indicative of a more permanent trend, then this may result in a lower valuation, even though those circumstances have been beyond the agent's control. That brings me to the question and answer session. But before I move on to that, I would like to mention Myerson's dedicated coronavirus page, which contains regular updates on various legal issues. This page is updated as further information is released by the government, and I would recommend looking at the page for useful insights and information. And the link to that page is shown on the slide. We also have other social media platforms, so please do subscribe and follow us as we continue to push out regular updates. And of course, if you need to get in touch with us, you have our contact details on screen. We now move to the question and answer session. And if you do have any questions, please populate these within the chat tab found in the icon bar on screen. Please bear with me for a few moments whilst I consider the questions which have been asked. So the first question: I am an agent in the UK representing 3 brands, one based in Canada, another in Germany, then France. I have 2 sub-agents working with me in the UK. Excuse me. Due to the current crisis, I have to consider terminating their involvement with my brands. How would I proceed, and what would their entitlements be? Okay, so the situation here appears to be that we have a principal, a main agent, and then sub-agents. The contractual relationship, presumably in this case, is that there is a contract between the principal and the main agent, and then a contract between the main agent and the sub-agents. The regulations will only apply to the contractual relationship between the principal and the main agent. In the event that the sub-agents are terminated, those sub-agents will not be deemed to be commercial agents and will not be afforded the protection of the regulations. So in this situation, if the sub-agents are terminated, they would not be entitled to a termination payment. Now, it's just worth mentioning here that the situation would potentially be different if the main agency were to be terminated. In that situation, it is possible that the sub-agents may be entitled to a share of the main agent's termination payment. The second question is, each year I mutually agree with my principal on sales targets, and in the definition sections of my contract, it is defined as such. Each year, with best endeavours, we use these figures as a focus to strive and achieve. And although sales targets is a definition, nowhere in the contract does it refer to sales targets or list them anywhere else, or in the termination sections. So my question is, although we mutually agree in writing the targets we set each year, as it's not referred to in my contract other than in the definition section, can the principal use this legally to terminate my contract and avoid paying compensation? So this brings us back to the point about sales targets and it being unlikely that this can be the basis for a principal to terminate the contract with immediate effect. In this particular case, this agent obviously has a contract and there are sales targets which are referred to in the definition section, but my view would be that unless the failure to meet those sales targets is ongoing and due solely to the fault of the agent, then it would be unlikely that the principal could use that to terminate the contract with immediate effect and avoid paying compensation. And the next question is, can a principal withhold payment for invoices that have not been paid? For example, invoices sent to my customers for the month of March became due for payment at the end of April. If my customer has not paid that invoice, can a principal withhold payment of commission to me? So this brings us back to Regulation 7 and the agent's entitlement to be paid commission by a long stop date. It sounds here as though the customer has not paid the invoices and the principal is withholding payment of commission. That would not be permitted. It sounds as though the order hasn't been cancelled. It's simply that the customer hasn't paid. So in those circumstances, the agent would have a right to demand payment, and if payment continues to be withheld, that's a breach of the agency agreement. The next question is, how do you calculate a figure for pipeline commission? As my work is done at the beginning of the year and floor models have been sitting on my retailer shop floor for the purpose of taking orders, usually for a 12-month period, can any future sales for pipeline commission be calculated by turnover figures for the current year? Okay, so the reference to pipeline commission is referring to an entitlement to be paid commissions on orders which are concluded after termination, and that is under Regulation 8. Now, my view would be that in the current circumstances where there are going to be less orders being concluded during the current period, this is undoubtedly going to have a negative impact on the value of Regulation 8 claims. And that is because under Regulation 8, the court doesn't look at average commission earnings. It looks at specific sales which were concluded prior to termination of the agency, but which conclude after the agency has been terminated. And it follows that if less sales are being concluded before termination, then that will have a negative impact on the value of the Regulation 8 claim. The next question is, how do you calculate a figure for termination notice, a 3 months payment? Do you take the past 3 years' turnover figures, divide by 36 months to get an average payment, then multiply by 3? So yes, what you have to do is you have to calculate an average monthly commission income. And then once you've established that average monthly income, you would then multiply by 3 to get your 3-month termination payment. However, I do think that where there is a decline in sales solely due to COVID-19, then it will be arguable that that period should be excluded from the calculation of the average earnings figure for the reasons we discussed earlier. And whilst no doubt principals will argue that period should be taken into account, I do think that agents will have the sympathy of the courts in that position if, as I say, the decline in sales for that period is solely due to reasons beyond the agent's control. The next question is, I was going to retire and expected a payout from my principal due to the virus lockdown. But due to the virus lockdown, I've been told that my business cannot be sold, so I will not be getting anything from my principal. Is this correct? This seems very unfair because if I had retired in January, I would have expected around £70,000 and now nothing. I'm 67. Okay, so where an agent retires and they have reached retirement age, which is usually taken to be age 65, then an agent is entitled to receive a termination payment. If an agent retires during the current lockdown period, or indeed in the foreseeable future where there continues to be a significant decline in sales, then the agent does not lose its entitlement to the termination payment, but it comes back to the issue of how is that termination payment calculated. And I think the important thing here will be to look at whether the decline in sales is a temporary blip in the principal's performance, or is it indicative of a permanent trend? And if it's just a temporary blip, then I think the agent will have a strong argument that when you calculate the termination payment, the commissions during that period should be excluded from the calculation. However, if the business is going to continue in decline, and of course some industries will be more affected than others, then the court may well say that that period should be taken into account for the purpose of calculating the termination period. So we will have to wait and see how that plays out with the courts. The next question is, I'm not being paid and the company also employs full-time representatives. The agents have been told that the account staff have been furloughed, so no invoices are being done, yet they've paid employment representatives their salary, and it appears to include commission based on an average. So the situation here sounds as though it's not that orders have been cancelled, it's simply that invoices are not being raised because the account staff are on furlough. If that is the case, then it seems to me that the principal here is in breach of its obligations, and the commission entitlement of the agent will remain, and the agent has a right to seek to enforce that commission is paid regardless of whether the customer pays the principal. And the next contract is, the next question. Good morning, I receive a monthly retainer plus commission. I have been asked by my principal to suspend payments until the end of the year. The contract will then start again in January. I will not have any income. Please advise what to do. Okay, so the difficulty here is obviously if the agent wants to keep the principal on good terms and keep it happy, there's probably an understandable desire, feeling that the agent should agree to this request. However, the agent doesn't know what's going to happen with the principal's business in the foreseeable future. And of course, if the agent does agree to this, it's not going to have any income until the contract restarts in January. My view would be in this case that the agent should assert his rights, and that the request to effectively suspend payments or to demand that payments be suspended would be a breach of the principal's obligations. And if the principal sought to enforce that, it would potentially amount to a repudiatory breach, which would entitle the agent in this case to terminate the agency agreement and would still be entitled to a termination payment. A further question, I have a new Spanish footwear factory. All my other factories are offering a discount on their season 20 orders, which have yet to be delivered. The Spanish factory is refusing to offer any discount on these orders that have not yet been delivered. They are only offering to extend payment terms. Some customers are cancelling their orders as there are no discounts being offered. The factory would rather receive cancellations than offer a discount, which seems crazy to me, as the volume of discounting on the market when we do restart is going to be high. Am I still entitled to commission on these orders that the factory cancel? And so I think we covered this point earlier, which is that if the principal is in any way involved in the cancellation of the orders, then the commission would remain payable to the agent. And it's really only going to be where the customer itself cancels the order and for whatever reason, and the principal plays no part in that the right to the commission would be extinguished. I think that brings me to the last question, which is this. I get paid commission for clients who continue to pay for the service on a monthly ongoing basis. My principal has stated that no commission will be paid as I cannot carry on my duties to shops, bars, companies being closed, etc. Some clients have suspended monthly payments. The principal has said this as he says he has to protect the financial situation and future of his company. From what you have said, I should be getting paid commission. If this is a breach, should I state that the agreement is terminated and I will seek termination payments? So it's important to say here that this sounds like a potential situation which could amount to a repudiatory breach, but an agent should be extremely careful in these circumstances not to take the step of terminating the agency without seeking advice, because once that happens, it can't just be reversed. And if the situation does not amount to a repudiatory breach, then the agent will have lost his right to the termination payment. So the agent in this case should assert his right to be paid the commission, which it sounds as though he is entitled to, because here it sounds as though the principal is wanting to take steps to protect its own business, but it can't simply do that and ignore its obligations to the agent. So the agent should assert his rights and possibly should assert that this may amount to a repudiatory breach, but no steps should be taken to terminate the agency until that agent has received some advice on the particular circumstances of the case. That brings me to the end of the question and answer session. A reminder that this webinar has been recorded and will be circulated to everyone later today. I'd like to thank everyone for their time today. And of course, if we can help in any way, please do reach out to us using the contact details of on the final slide. Thank you.